The matter of Cobalt Data Centre and Commissioner's Majesty.
Yes, Ms. Shaw.
Good morning.
Morning.
So I was about to move on to ground 2.
Yes.
So the second ground of appeal concerns the correctness of the tribunal's conclusion that part of the price was paid for the EZAs, Crsas, and the discharge of the arranger's fee. Although strictly only the Crsas and the arranger's fee are in issue because of the outcome of the JR. So there are essentially two parts to this ground of appeal. First, we say that the approach which the Upper Tribunal took to the legislation was an overly granular approach. And secondly, we say that the Upper Tribunal's conclusion is predicated on a fundamental mischaracterisation of the nature of the EZAs, Crsas, and arranger's fee, which produces a result which is at odds with the commercial reality of the transaction and leads to a wholly artificial apportionment of the price. So starting then with the tribunal's approach to the legislation, the statutory question to which section 296 gives rise is what was the capital sum paid for the relevant interest?
Yeah.
And we say that in answering that question, what the court is not required to do is identify and isolate each and every associated right and benefit acquired alongside the relevant interest as part of an overall package and then dissect the price amongst those elements.
The relevant interest is the developer's right under the golden contract to have the building built.
Correct.
Is that right?
Yes, and that's section 286, I think. Yeah, correct.
And the developer's right under the golden contract to have the building built did not include any sort of rental guarantee.
No.
Or any sort of capital repayment scheme, or any of the other
components identified. Correct, correct.
So one might have thought that if you ask what is being paid for the developer's interest or for the relevant interest, you ask, well, what did the developer have to sell?
Well, you do certainly have to ask that question. Our case, in a nutshell, is if there are ancillary benefits and rights which go alongside that, then it's not appropriate to regard the price as having been paid for that. In the same way that if you buy shares with the benefit of a tax deed and warranties, obviously the original holder of the shares doesn't have those rights under the tax deed and warranties, but you still regard the purchaser as paying for the shares rather than paying for the shares and the tax deed and warranties. They are ancillary elements which support the transfer of the shares, and that's really what we say about all of these other rights and benefits. They are ancillary elements which support the transfer of the relevant interest, the developer's right to have the building constructed, and they aren't as such elements which it's appropriate to regard the LLPs as having paid part of the price for.
So he gets them for free, basically?
Essentially, they're part of the overall package, yeah.
Well, but yes, well, they may be part of the overall package, but that doesn't necessarily answer the question, does it? I mean, if I buy a new washing machine, I'm offered insurance, so that if it breaks down within 3 years, somebody else will pay for the repair.
Yeah.
And would it matter whether I pay separately for the insurance or whether the retailer says, well, this is the package, it consists of a washing machine plus insurance? Well, I'm still paying something for the insurance, aren't I? Maybe part of the overall price that I've agreed.
Well, in that instance, I would say you certainly are paying for the insurance, because that is a sort of an added extra, if you like, that you are offered and that you pay for. But a washing machine, a brand new washing machine, will often come with a 2-year warranty. And in our submission, you're not also paying for that 2-year warranty. It is something which comes alongside the sale of the washing machine, but you're not regarded, when you hand over the money for the washing machine, you wouldn't regard yourself as paying separately for that 2-year warranty.
Yeah.
So this sort of granular approach, we say, was implicitly rejected by the House of Lords in the BMBF case and by the Supreme Court in the Tower End cashback case. So if we can briefly turn those up. BMBF is in volume B, tab 24. The question in BMBF was whether the taxpayer had incurred expenditure of £91 million on a gas pipeline going under the North Sea. And it acquired that gas pipeline as part of a sale and leaseback transaction. And the question was whether BMBF had incurred £91 million on the gas pipeline so as to qualify for plant and machinery allowances. Now, as well as the pipeline, BMBF also obtained the benefit of certain security arrangements, which essentially guaranteed that BMBF received the rent payable under the leaseback by using the purchase price as cash collateral for the rent payable under the leaseback. So, in those circumstances, there was plainly scope for the court to approach the matter by reference to the totality of rights and benefits obtained by BMBF, and indeed that was the approach taken by Mr. Justice Park below, and that's set out in paragraph 23. On page 471. So he said, it is true that in a strictly legal sense, one can say that BMBF incurred expenditure on the provision of the pipeline. That is what the two acquisition agreements said. However, in light of the Ramsey authorities, I consider that I have to interpret and apply the statute in a wider way. I have to ask, on what did BMBF really incur its expenditure of £91 million? Was it really incurred on the provision of the pipeline, or was it really incurred on something else? My answer is that the expenditure was really incurred on the creation or provision of a complex network of agreements under which, in an almost entirely secured way, money flows would take place annually over the next 32 or so years so as to recoup to BMBF its outlay of 91 million plus a profit. So that money coming back to BMBF was the rent due under the lease back. So Mr. Justice Park's approach was that, looking at the wider contractual context, what the taxpayer had in fact paid for was essentially a secured rental stream. Now, that was not the approach which the House of Lords took. And if we turn to the end of Lord Nichols' speech in 41 and 42 there, he takes a much more straightforward approach. He says, so far as the lessor is concerned, all the requirements were satisfied. And he says just above D, the finding of the special commissioners that the transaction had no commercial reality depends entirely upon an examination of what happened to the purchase price after BMBF paid it to BGE. But these matters do not affect the reality of the expenditure by BMBF and its acquisition of the pipeline for the purposes of its finance leasing trade. If the lessee chooses to make arrangements, even as a preordained part of the transaction for the sale and leaseback, which result in the bulk of the purchase price being irrevocably committed to paying the rent, that is no concern of the lessor. From his point of view, the transaction is exactly the same. No one disputes that BMBF had acquired ownership of the pipeline or that it generated income for BMBF in the course of its trade in the form of rent chargeable to corporation tax. In return, it paid £91 million. So on Lord Nichols' analysis, as far as the taxpayer was concerned, it had incurred the expenditure on the acquisition of the pipeline, even though it also acquired a secured rental income. And no doubt that was a valuable benefit to it.
But that's
So
slightly, sorry.
BMBF is the lessee, is that right?
That's it. BMBF buys the pipeline and then it leases it back to BGE.
Oh, I see.
So BGE is the original owner of the pipeline, sells it to BMBF, and then BMBF leases it back to BGE. And what BMBF gets is the pipeline and a secured rental income. So what BGE did was it used that purchase price essentially as cash collateral to secure the rental due to BMBF.
So, is this right? Applied to this case, BMBF is the LLP. It pays the money to the developer, and what the developer does with the money doesn't matter. Is that how you apply it to this case?
Well, there isn't a, it's not sort of directly applicable because there isn't a sale and lease back, but the analogy that I draw is that what BMBF acquired was both the pipeline and additional rights and benefits in the form of a cash collateralized secured rental income. And what the House of Lords says is, well, we're just going to look at what the expenditure was on. It got the pipeline. The fact that there were other valuable rights and benefits alongside that doesn't mean that you take this very granular approach to identify each and every right acquired.
I'm not sure that's what this case says at all, Miss Shaw, because the issue for the House of Lords was whether or not the commercial reality of the transaction was a sale with an acquisition of ownership rights or not. And the judge had held that it wasn't on Ramsey principles because of all the cash flow arrangements and so forth. And the heart of it in Lord Nichols' speech surely is in para 42. No one disputes that BMBF had acquired ownership of the pipeline or that it generated income for that. So the real question was whether or not it had acquired ownership and paid something in return for that. But I'm not sure that this case is authority for the proposition that when you're trying to work out how much somebody paid for something, you ignore any bolt-ons or add-ins. Because it was a stark choice between treating it as a leaseback and a cash flow arrangement or an ownership arrangement.
Yeah, I mean that's a fair comment. That it certainly wasn't argued that only a portion of the 91 million was paid for the pipeline and a portion elsewhere. It's sort of a more general point that I'm making, which is that in this case there was scope for that type of analysis, and that wasn't the road that the House of Lords went down. Can we briefly turn to return to Tower M, which is behind tab 30? So we looked briefly at some of the dicta in the first of the issues in Tower M, the procedural issue. The second issue in Tower M is that it concerned the question of whether the investors had had incurred expenditure on the acquisition of software rights, and again, the sort of general point that I'm making is what you don't see in this case is the Supreme Court engaging in this sort of painstaking review of the contracts and the identification of the various rights and benefits acquired alongside the software rights. And if we turn very quickly to paragraph 77, in essence, below letter B there, the outcome in Tower M depended on the premise of the decision was that the money which represented the borrowing, which was 75% of the amount paid by the LLP, didn't go to M cashback even temporarily. So the proportion of the price, which was made up with borrowings, never actually made its way into the hands of the vendor. It passed in accordance with a solicitor's undertaking straight to R&D, which was the bank. So it sat there as a security deposit. So in Tower M, again, we don't see the Supreme Court asking what are the various rights and benefits acquired alongside the software rights. It just simply analyses it by reference to the flow of funds and concludes that part of those funds never actually made it into the hands of the vendor. So in those circumstances, it simply couldn't be said that the LLP had incurred expenditure on the acquisition of software rights when that proportion of the price never actually reached the vendor.
But isn't what Lord Walker says at 76 the approach which the tribunal took? He looks at Ensign,
Yeah.
and that says no real loan, no real expenditure.
Yes.
And he says at G, here the issue was whether there was real expenditure, and then he emphasises, on the acquisition of software rights.
Yeah.
Well, Justice Mosley gave the right answer to the wrong question. Transfer of ownership indicated the reality of some expenditure, but was not conclusive as to the whole of the expenditure having been for that purpose.
Yeah.
Isn't that exactly what the question that the tribunal asked itself? Was the whole of what the LLPs paid for the purpose of acquiring the developer's rights under the Golden Contract?
That was the question, yes. But the analysis in Tower M was not let's have a look at all the various rights and benefits that were acquired alongside the software rights. It took a much more a realistic view of the facts, essentially, and it said, well, you say you've paid 100 for these software rights, but actually 75 of what you paid never finds its way into the pocket of the vendor. So in those circumstances, you cannot realistically be said to have spent that 75 on acquiring the software rights. It never actually gets to the vendor.
Well, that's because there wasn't any case of their spending the remaining money on something else.
But there would have been other rights and benefits acquired alongside, and in fact there were particular finance arrangements in Tower M itself. So
just look at paragraph 79, you'll see that's explained.
So there was no evidence as to the value of the software rights in Tower M.
I think he decided in principle there could have been a restriction, but he wasn't going to do it because it wouldn't be fair at this stage in the case. That's what he's saying in this confusing case.
Yeah, so the simple point we make is that the analysis in Tower M is not about identifying these various rights and benefits. The explanation is, at the bottom of 75, that the money in this case went into a loop, and it never actually went to the vendor.
But both of these are cases where the real issue was whether the transaction was in effect a sham or what the real character of the transaction was. So that the court was focusing in each case on that issue. Was it a genuine sale and purchase, and how much money had been paid for an acquisition of a proprietary right in whatever it may be, the software or the pipeline as the case may be. Neither of these cases seem to me to shed very much light on the question of what you do when somebody gets a package of rights and obligations, and the question is is it an integral part of the sale and purchase, or are you getting an add-on for which you're paying extra value?
Yeah, and our point is simply that one always acquires a package of rights and benefits in any commercial transaction, but what we don't see is the courts, well, in these two cases, going down that route. We see them looking at it in a different way, and that's really the point that I'm making.
Can we just look for a moment at paragraph 88 in Lord Hope's speech? He says it requires it to be demonstrated in this case that the whole of the claimed expenditure was actually incurred on acquiring rights in the software. That's a factual inquiry, the extent and depth of which will always depend on the circumstances of each case. Yeah. Does that put you in a difficulty? This is a factual question for the Upper Tribunal.
Well,
just for completeness, we can see that Lord Roger, Lord Collins, Lord Carr and Lord Clark and Dyson agreed with both speeches.
Yeah, I mean...
Judgments, rather.
Our essential submission is that the approach which the Upper Tribunal took was wrong.
Yeah.
So the second part of this ground is that we say that the Upper Tribunal's approach proceeds on a fundamental mischaracterisation of the nature of the EZAs, Crsas and arranger's fee, and that thereby produces a result at odds with the commercial reality of the transaction. And the starting point in our analysis is that where a relevant interest is sold alongside a number of ancillary rights and benefits, that does not mean that the price should be divided amongst them. And by ancillary, what we mean is elements which are supportive of the overall transaction rather than being ends or aims in themselves.
Sorry, just a moment. Ancillary means supportive of the overall transaction.
Yeah, of the overall sale of the particular item, rather than being an end or an aim in themselves. So it's invariably the case that in a commercial transaction for the sale of an asset, the transaction will incorporate a variety of related rights and benefits. And indeed, at paragraph 251 of the Upper Tribunal's first decision, it accepts, by way of example, that a property...
Sorry, which paragraph?
251.
Yeah. Do you want us to turn it up?
Yeah. Thank you.
Have we finished with time and cashback?
I have. You can pop that away. Yeah, thank you. So, in 251 here,
Yes.
so here, the Upper Tribunal accepts, by way of example, that a property or share sale will typically include some sort of warranty of value. However, as a matter of substance, what the purchaser pays for is the asset, even though it comes with the benefit of a warranty of value. And even though the price payable for the asset is going to be higher as a result of that warranty. But in that example, we say it would be wholly artificial and contrary to the commercial reality to attribute part of the price to the warranty. And the Upper Tribunal appears to accept that proposition in 251. So similarly, we say in this case, what the LLPs paid for was the assignment of the developer's rights under the golden contract, and not each and every associated right and benefit that went alongside that assignment. None of the items which are identified by the Upper Tribunal in paragraph 240 are ends in themselves. Their purpose was to support the sale of the relevant interest. Their purpose was to ensure that the LLPs got what they were paying for. And we say, as such, they ought properly to be characterised as ancillary to the relevant interest.
Stretching it a bit to say that an arranger's fee is something which is supporting the acquisition of the interest.
No, well, no, that is true. But there's more than one way for something to be ancillary. Yeah. And again, we would say plainly, the discharge of the arranger's fee is not an end in itself. I'll come on to what we say the analysis is of each of these, but it is ancillary in a different way.
One problem with the way you've just put it is that it rather begs the question. You say the purpose of these benefits was to ensure the LLPs got what they were paying for, but the question is, what were they paying for?
Well, they were... How they approached the transaction was that they were buying an income-producing data centre. They regarded it as they regarded their investment as an income-producing asset, and that's what they.
But if they bought it for cash, they wouldn't have needed the capital support repayments.
No, they wouldn't, and that's the Crsas are there to ensure that the capital value of the investment is as it's been said to be.
Well, it's to ensure repayment of the loan.
Yes, in the event that the capital value is not sufficient to enable that to be discharged on a refinancing. It's all tied in with the capital value of the investment. The developer is saying, this is the price, it's 150 million, and the LLP says, okay, well, if you're wrong about that, then you have to help us repay the loan. So can we briefly return to the SDA? And I'm afraid I'm also working from volume C. I don't know which volume you're working from now.
Well, the purpose of the core bundle is to give us the documents that we need. And it's a bit disappointing if the version in the core bundle is not the one that people are working from.
Okay, well, I've
been using the supplementary core bundle.
Okay, apologies. I'll refer you to clause numbers then. That might make life a bit easier. So can we start with clause 3?
Yes.
So in consideration for the developer assigning the benefit of its rights under the principal contract, pursuant to the deed of assignment and fulfilling all of its obligations under this agreement, the owner shall pay the price to the developer on the completion date. Now, the developer's obligations are then set out in the remainder of the agreement. And you can see from even just the briefest of glances that there are numerous and varied obligations on the developer, and certainly that go far beyond the 4 obligations identified by the Upper Tribunal in paragraph 240. So, for example, in clause 4.1, the developer is required to deliver or procure the delivery of various documents. Now, it's not suggested that those obligations constitute separate rights and benefits for which part of the price was paid, but it's not apparent as to why. Clause 4.2 contains some of the components identified in paragraph 240. So in clause 4.2a, 1, 2 and 4, the developer is obliged to deposit around £71 million in the restricted account, which is then used as part of the cash collateral to secure the bank winter loan. The remainder of the cash collateral is actually an obligation of the contractor, and that's clause 4.2a(3). The arranger's fee, or the right to the discharge of the arranger's fee, appears in clause 22. Upon the completion date, the developer shall pay to the owner's solicitors the arranger's fee in respect of the performance by the arranger of the arranger's services. So that covers off the arranger's fee. The remainder of the components of the rights and benefits identified in paragraph 240 are actually derived from the services agreement and the side letter, which are, I don't think the services agreement is in the core supplemental.
It is.
It is, okay. So in terms of that agreement, clause 2.1.
Yeah. The services agreement starts at page 267, the supplementary clause. So which clause?
Clause 2.1.
Yes.
So clause 2.1 establishes the obligation to pay the yearly sum. And the yearly sum is defined on the previous page as being, you can see the aggregate of 1, there's an amount there which is essentially interest on the bank winter loan. Then over the page, 2, there's an amount there in respect of the rent, that's the ground rent. And then 3, there's an amount, you can see, in respect of the annual operational costs of the owner, the LLP. So those 3 components constitute what the Upper Tribunal calls the EZAs. And then at C, you can see essentially what the Upper Tribunal calls the RSAs, the obligation to ensure that the rent received by the LLPs once the building has been tenanted is equal to the target rent, namely £170 per square foot.
That's C, is it? Or the
That's
definition?
C, yeah.
This is all of these items of expenditure relate to future events after the acquisition of the property, don't they?
Yes.
And are compensation for potential downturns in rental or capital valuation, but it's all to, as you say, to ensure that the value is what it was said to be.
Yeah.
But on the other hand, all of this money is being paid for something after the property has been acquired.
That's true. It is all post the acquisition of the relevant interest. These obligations would kick in at that point.
And so I'm just wondering why, on that basis, being very simplistic about it, it could be said that it's being paid for the acquisition of the relevant interest if it relates to something that you're gaining after you've acquired it.
Well, in the same way, I suppose that with a warranty of value, you get that warranty at the point at which you buy the dishwasher or whatever, but you might not need to claim on it for 2 years down the line or whatever. So its benefit, if you like, might not be realised until a later point, and it's the same with the yearly sum. You're getting that obligation, that benefit at the point at which you acquire the relevant interest, even though what it's doing, what the yearly sum is doing, is basically ensuring that the LLP has an income from which to defray its own income expenses. The difference between the EZAs and the RSAs is, if you like, the metric by which they are computed. So the EZAs, in the period pre-letting, the EZAs are computed by reference to the minimum amount of income stream that the LLPs need to defray its expenses, whereas in the post-letting period, the benefit is computed by reference to the target rent that the developer is essentially guaranteeing the LLP will attain. Okay. Oh, okay. So apparently, my lord, you're looking at the draft SDA, the draft services agreement. Is that right? Yes. Okay. So the page that you want is 364. That's the executed version.
Sorry, 364?
364. It's tab 5.
Right.
Yeah.
Yes, I see.
Yes, I see.
Well, I was looking at it as part of the SDA.
Yeah, I
Did
don't
it
think there's any.
change?
I don't think there's any difference between them, but just so that you're aware,
Right.
I think that's right.
Because the SDA says that the party's going to enter into this service agreement. So,
Oh, it's clearly contemplated. Yes.
so I was looking at what you've called a package, which
Yeah.
the LLP's got under the SDA. But anyway, all right. If there's no change between them,
I don't think there
doesn't
is,
really
but just
matter.
so that you're aware.
Right.
So,
Yeah.
so it's 2.1 of the services agreement that establishes the obligation to pay the yearly sum, and as we see, the yearly sum comprises those two
Yes.
elements which the Upper Tribunal separates out. Clause 5.4 this is the provision which establishes the developer's obligation to provide an interest-free subordinated loan in the event of any shortfall on a refinancing of the bank winter loan. So that's where we get that element. But again, we make the point that a brief glance at the services agreement reveals that there are numerous other obligations on the developer under this agreement. So, for example, clause 5.2, the developer undertakes to use reasonable endeavours to procure refinancing for the bank winter loan on the grant of a lease. Clause 6, the developer agrees to act as the LLP's agent on a disposal of the investment and to negotiate the terms. Clause 8, the developer agrees to seek a tenant or tenants to take a lease of the data centre. Now again, it's not suggested that these should be treated as separate assets for which part of the price was payable, but again, we say it's unclear why not. And then finally, which I don't think is in the core supplemental bundle, is the side letter, and that can be found in bundle C behind tab 35. Are you having another bundle malfunction?
I'm saying nothing. And then, Ms. Shaw, thank you.
Sorry, it's the very last couple of pages. So this is the side letter, and this is what establishes the right of conversion, so the right to convert the developer's loan into an equity contribution, to a capital contribution. And so you can see that at the paragraph numbered 1. At any time after entering into the developer loan, you may be required by us to make a capital contribution sufficient to repay all or part of the developer loan.
Sorry, where are we? Page 1273.
1273 it's the paragraph numbered 1.
Oh, I see. Yes.
Just below the 3 Roman numerals. And then over the page 1274, the paragraph numbered 4, you can see there that the fee payable is 30% of the first 4.33 million of carried interest. So that's the final element of what the Upper Tribunal describes as the Crsas.
Yeah.
So we say that, taken to its logical conclusion, the Upper Tribunal's decision ought to mean that the price is divisible amongst all of the rights and benefits to which the contracts gave rise, not just those 4 elements identified in paragraph 240, but in our submission that would plainly defy commercial reality, not to mention would be wholly impractical. So we ask, somewhat rhetorically, what then is the rationale for identifying and isolating those 4 elements set out in paragraph 240?
Well, the rationale that the Upper Tribunal took was that these benefits were capable of separate identification as separate assets.
But why? Why not the
Well,
right?
it's a question of fact.
Well, but why isn't the developer's obligation to find a tenant a separately identifiable right? It's right there in the contract.
No, might well be.
Well, we say that.
I mean, some things are obviously integral wholes. Obviously, I mean, if I buy a car, I'm not paying separately for the brakes and the accelerator and the engine and so forth. I'm buying a composite. But if I choose the add-on alloy wheels, that might be different. Might be. It's a question of fact.
Well, what the tribunal has not done is provided us with any explanation as to why those are the 4 that have been, if you like, singled out for special treatment.
Right.
So then, in terms of the analysis as to the nature of those 4 items identified in paragraph 240, the Upper Tribunal's reasoning begins at paragraph 250, And it starts there with the RSAs.
Just a moment. Yeah.
250, yeah. So this is where the analysis begins as to the nature of these various rights and benefits. So in terms of the RSAs, the Upper Tribunal accepts the analogy with a warranty of value on the basis that the RSAs effectively ensure that the LLPs receive the target rent, even if a tenant is only willing to pay a lower amount. And on that basis, the tribunal accepts that the RSAs are properly to be regarded as ancillary to the relevant interest. And we respectfully endorse that reasoning. Now, the revenue take issue with the Upper Tribunal's reasoning in that regard. And in paragraph 27 of their response skeleton, they contend that the RSAs can't really be regarded as a guarantee of value when they don't guarantee that a tenant will be found. And that is, of course, true, but in our submission, the analogy still holds good.
The HMRC will refuse permission to appeal on that point.
Well, the point is certainly academic, yes, but
Yeah.
they still make the point that
Well, I know. I mean, I'm not quite sure what procedurally is correct about this. If they've been refused permission to appeal on that point because it's academic, then that point, at any rate, at HMRC's behest, is not a point that we should be going into. If, on the other hand, you wish to say, as you do in your skeleton argument, that there is an inconsistency between the treatment of the RSAs on the one hand and the other benefits on the other, then it may well be that we would have to decide, A, whether there is an inconsistency, and B, if there is, which is right. So...
Yeah, I mean, and I think that's really how the revenue put it. They say that the correctness of that reasoning feeds into the analysis on the other elements, which of course I am challenging.
Yeah.
So it's not so much that it would, the upshot of it would have a difference. It's more in terms of analysing the reasoning and whether the reasoning holds good on the other elements. So in our submission, the analogy that the Upper Tribunal is prepared to accept in relation to the RSAs holds good, notwithstanding the fact that the RSAs cannot guarantee that a tenant will be found. What the RSAs guarantee is that when a tenant is found, the LLPs will receive the target rent. And we say that that is still a warranty of value. It is economically equivalent to a warranty by the developer that the data centres will generate rental income of that amount.
But only if there's a tenant.
Only if there's a tenant, but that is still a warranty as to the income that can be generated by the data centres.
And what happens if a tenant isn't found?
Well, I mean, that's the position that we were in. So essentially, you don't get to the stage of the RSAs. The ESAs have kicked in because the LLPs still have their.
So you say that the RSAs are there to deal with with one scenario, and the ESAs are to deal with the alternative scenario, and they're two sides of the same coin.
Yeah, essentially, yes.
Would it have made any difference if the developer had agreed to take a lease at the target rent and then assign it once a tenant had been found? So there was a sale and lease back. Would it have made any difference? You'd say that the lease back was still part of what the developer had to sell?
Yeah, well, I suppose that would have been a form of rental guarantee.
Well, exactly. That's why I asked
Yeah.
you. Suppose instead of taking the form of a guarantee, the developer had said, yes, we will pay the target rent.
Yes.
Take a lease straight away. We'll pay the target rent. We'll look for a tenant, and as soon as we've found one, we'll assign the lease, so we'll get out of having to pay it.
Yes.
You would still say, would you, that everything was paid for the developers in the relevant interest?
Yes, we would still say that everything was paid for the relevant interest. That's just another form of rental guarantee. So the next section of the Upper Tribunal's decision addresses the ESAs, and the Upper Tribunal breaks the ESAs down into their component parts. So there's the obligation to pay ground rent, the obligation to pay operating expenses, and the obligation to pay interest on the bank winter loan. So as far as the obligation to pay ground rent is concerned, the Upper Tribunal's analysis is that that is an obligation which relates to the head lease and not to the relevant interest, and so that cannot properly be regarded as ancillary to the relevant interest. And similarly, it took the view that the LLP's operating expenses can't properly be regarded as ancillary to the relevant interest. And then in terms of the obligation to pay interest, it considered that point to be more finely balanced, although ultimately it concludes at the end of 253 that in essence it's a right to assist the purchaser in servicing its lending rather than a guarantee of value. Now, we would accept that viewed in isolation, the ESAs can't properly be described as a guarantee of value because, for the reason I've already mentioned, unlike the RSAs, which are computed by reference to the target rent, i.e. by reference to the rental value of the investment, the ESAs are computed by reference to the LLP's expenses. The point, we say, is that the ESAs are not a standalone item. They are one of the components of the yearly sum, and the function of both the ESAs and the RSAs is essentially to provide the LLPs with a synthetic rent, if you like, from which to service its expenses, and ensure that it receives rent once a tenant is found in the amount of the target rent. So
Well, I don't quite follow that because they've got nothing to do with rent. This is all before a tenant's found.
well, it's a
This is presumably during the construction period.
yeah. Ordinarily, how a landlord, if you like, services its income expenditure is out of its rental income stream. Before the building is built and before a tenant has been found, there is no rental income to enable the LLP to service its income expenditure. And so what the ESAs are doing is providing the LLPs with an income stream in order to service its income expenditure. So that's why I call it a synthetic rent. It's a, if you like, it is providing that income stream which would ordinarily come in the form of rent from a tenant.
Well, maybe. I mean, some landlords don't need rent to cover their operating expenses, at least not from this property. They've got other ones which do that.
Well, they might
Some
do, but-
landlords don't need to borrow money in order to acquire property.
No, but, well, ordinarily, I think you would probably assume that the expenses incurred in relation to a particular rental property will be met by the rent from that property. I mean, we only have
in due
this.
course.
We only have this, yes, in due course, but we're dealing with a forward-funded arrangement whereby the LLP has paid up front for a building which has yet to be built, let alone tenanted, and this is a construct which enables the LLP to have an income stream, even though it doesn't yet have the building. So in essence, the ESAs are simply another component of that right to an income stream from the investment. The difference between the ESAs and the RSAs is the period to which they relate. ESAs relate to the pre-letting period, RSAs to the post-letting period, and as I say, the metric by which they are computed. ESAs computed, they guarantee a minimum amount of income so as to cover the expenses. The RSAs are computed by reference to the target rent. So we say that the proper analysis of the ESAs is that they form part of an overall rental guarantee for which the yearly sum provides. Their purpose is to support the income position. And we say, as a result, they should be regarded as analogous to a warranty of value. And of course, in the JR, they were to be treated as an overall part of a rental guarantee. That was the upshot of the JR, that the ESAs, that the revenue themselves had regarded this as simply a component of a rental guarantee.
Yeah.
So in our submission, the distinction which the Upper Tribunal attempts to draw between the RSAs and the ESAs is more illusory than real, because they are essentially two parts of the same guarantee. But in any event, we say even if it is right to isolate the ESAs in the way that the Upper Tribunal did, they cannot, even if they aren't a warranty of value viewed in isolation, they are nonetheless ancillary to the relevant interest, in the sense that they arise as a result of or in connection with the purchase of the relevant interest, rather than constituting an end in themselves. So the Upper Tribunal then moves on to the Crsas, and you can see in 255, it opens its analysis by indicating that the proper characterisation of the Crsas flows inevitably from its characterisation of the ESAs.
Yeah.
And in our submission, the error in the Upper Tribunal's analysis of the Crsas is in essentially aligning it with the ESAs. We say that the Crsas are doing something very different indeed. And in fact, the fundamental error in the Upper Tribunal's approach to the Crsas is that they focus on only one element of the Crsas. So
just hold on a moment. So does that mean that even if the Upper Tribunal were right about the expense support, they were wrong about the capital repayment support?
yes.
Yeah.
Essentially because they align them with
Yeah.
the ESAs when actually they're doing something very different. So you'll recall from paragraph 240, there are three components to the Crsas. There's the cash collateral, there's the developer loan, and then there's the right of conversion. And what the Upper Tribunal does in these paragraphs is essentially to focus on only the first of those components. This analysis only concerns the cash collateral.
Yeah.
And the reason why it does that is because we didn't make any submissions to the Upper Tribunal about the developer loan for the right of conversion because it had never been suggested at that point that part of what we paid for was the developer loan and the right of conversion. Now, we don't particularly take issue with what the Upper Tribunal says in 257 about the cash collateral, namely that it was essentially financial assistance to enable the purchase of the relevant interest to take place. That is what the cash collateral did. The point is that that's not the only thing that the Crsas did, and that is certainly not the function of the developer loan and the right of conversion, which were there to underpin the capital value that had been represented by the purchase price. Now, as regards the cash collateral, that is an element of the Crsas to which neither of the parties' valuation experts attributed any value whatsoever. If I can ask you to turn up, please, volume A of the supplemental bundle, behind tab 14, which, I'm sorry, is the final tab in this bundle. So this is the joint statement of the experts, Mr. Williams for the LLP and Mr. Mackey for the revenue. And if you turn to page 440, in box number 1, this is areas of agreement between the experts. Box number 1. Value of the funding of the restricted account so as to provide cash collateral for the bank winter loan is ascribed 0 value by both experts in their income-based approach to valuation. And the reason why Mr. Williams ascribed no value to the cash collateral was because he regarded the benefit of the cash collateral as essentially equivalent to the return which the LLPs would have been entitled to expect on the forward funding of the construction costs. And Mr. Mackey put it slightly differently, and you can see that in his opinion, the benefit of the cash collateral had no value because what it did was to reduce the amount which would otherwise have been payable under the EZAs. In other words, the cash collateral is what enabled the interest rate on the bank winter loan to be so low as 0.5%. If you hadn't had the benefit of the cash collateral, a higher interest rate would have been payable, and that would have increased the amount due under the EZAs or payable by the developer under the EZAs. But the big point is that on either analysis, the cash collateral element of the Crsas had no value. So the real value or benefit to which the Crsas gave rise were the right to the developer loan and the right of conversion. And those elements are not addressed by the Upper Tribunal in this section. Now, as to those elements, we say that they are plainly analogous to a warranty of value. The effect of the developer loan obligation was that if the capital value of the data centres was insufficient to enable the bank winter loan to be fully repaid on a refinancing, then the developer had to meet that shortfall. And we say that that is economically equivalent to a guarantee of the capital value of the investment. Similarly, the effect of the right of conversion was to enable the LLPs to reduce their overall level of debt in the event that the capital value on a disposal was insufficient to enable them to repay their liabilities. And again, we say that is economically equivalent to a guarantee of the capital value of the investments. And indeed, we say that when it came to the second decision, the Upper Tribunal essentially acknowledged that. So in paragraph 68 of the second decision, the Upper Tribunal...
Just a moment. Second decision, paragraph 62.
68.
68.
See there that the Upper Tribunal describes the other rights and benefits, the purpose of them being to ensure that value flowed back to them from the developer to the extent that the price turned out to be an overpayment. So what we say the Upper Tribunal is describing there is economically equivalent to a warranty or a guarantee of value. And so for those reasons, we say that the Upper Tribunal ought properly, in line with its reasoning in relation to the RSAs, to have regarded the CRSAs as analogous to a warranty of value and therefore ancillary to the relevant interest. And also, while we're in the second decision, it's also notable in paragraph 66 that when it came to the question of valuing the CRSAs, the Upper Tribunal's view is that they weren't really separate and distinct from the relevant interest. So then finally, we come to the arranger's fee. And that starts at 259, the first decision. 259.
Yeah.
And Melody's quite right. The arranger's fee is not analogous to a warranty of value, but we say it's nonetheless properly to be regarded as an ancillary element. So in 261, or 260, the Upper Tribunal sets out what the arranger's services were, and then in 261 it says that those services, in respect of which the arranger's fee was payable, were provided to and for the benefit of the LLPs. And as a result, defraying that expense can only have benefited the LLPs. And in our submission, that is an oversimplification of the position. No doubt the services were for the benefit of the LLPs, but they were also for the benefit of the developer. They were the services that enabled the investment to get across the line. they enabled the investment to take place, and that is plainly something in the developer's interest as well. Now, in commercial transactions, it is perfectly commonplace for an intermediary to look to one or both parties for a fee. And indeed, we say it's not unusual for one party to a transaction to agree to discharge the other party's fee. And no doubt the reason that they would agree to do that is because they consider it to be in their commercial interest to do that. It's in the commercial interest of getting the deal done. But it would be highly odd, we say, to regard the giving of that undertaking as a separate asset for which part of the price has been paid. And indeed, in this instance...
So just pause a moment. I decide that I am going to buy an unused industrial building in an enterprise zone, which I think qualify me for relief. And I instruct my solicitor to do the conveyancing. If I pay my solicitor, I can't claim the expenses, that expenditure, as qualifying expenditure, I believe.
Correct.
But if I get the vendor to pay my solicitor, and I increase the price as a result, then I can.
Well,
is that right?
Let's step away from the world of EZAs for a minute. I believe there are arrangements whereby if you buy a home from a house builder, they will agree to pay your conveyancing costs and even your estate agent costs in terms of selling your house.
Sometimes your stamp duty.
Sometimes, and lots of things like that. But what you are paying that house builder for is the house. You're not separately paying them for that right to discharge your conveyancing fees and so on. So we put it into an enterprise zone. We say the analysis isn't any different. If, of course, the evidence had been the purpose of this is to fluff up the amount of the price paid, then that might be different. But there is no evidence to that effect. The effect of the Upper Tribunal's analysis is that the LLPs agreed to pay £9.5 million or whatever the arranger's fee was for the right to have a fee of £9.5 million discharged. Now that makes no commercial sense whatsoever. So, for those reasons, we say that the right to have the arranger's fee discharged was not an end in itself. It was simply an ancillary right or benefit that went alongside the transfer of the relevant interest. And it was naturally in the developer's commercial interest to agree to discharge it. And again, returning to the second decision, in paragraph 67, we looked at paragraph 66, where in respect of the Crsas, the Upper Tribunal says they're not really separate and distinct assets. And essentially, the Upper Tribunal reaches the same conclusion in relation to the arranger's fee. So at the end of 67, it says this reasoning applies equally to the arranger's fee. So for all those reasons, we say that none of the items identified by the Upper Tribunal in paragraph 240 are properly to be regarded as separate assets for which part of the price was paid. They are properly to be analysed as ancillary elements, and as such it's not appropriate to regard the LLPs as having paid part of the price for those rights. And indeed, that analysis accords with how the parties themselves approached the pricing of the transaction. So in 272 and 273 of the first decision, you can see there that how the price was computed by the developer and assessed by the LLPs was simply by reference to the headline rent and the yield plus the benefit of the EZAs. So dividing up the price amongst these various rights and benefits in the manner suggested by the Upper Tribunal, we say, contradicts the reality of the transaction.
Yeah.
So that's all I've got to say on ground 2. So our third ground of appeal is that the Upper Tribunal erred in its approach to the apportionment issue. Now, the apportionment...
If you're right on ground 2, we needn't worry about ground 3, is that right?
That's right. Yes.
I'm going, right at the end of all this, I'm going to go through the various permutations
Yes.
of what we actually do need to decide and so forth. But anyway,
Yes.
all right, so ground 3 assumes you failed on ground 2.
Yes, exactly. So the apportionment issue arose because of the Upper Tribunal's conclusion that the price had been paid for the ESAs, the Crsas and the arranger's fee. And it concludes at 286 that an apportionment is required as a result of that.
Now, you place a lot of weight in your written argument on the word apportionment. If they had used the word disaggregation, would you still be making the same point?
Well, we say that an apportionment is what is required if you have a price, a global price payable for a number of discrete elements. We say that in those circumstances an apportionment is required. So if it had used a different word, or if it had said up front no apportionment is required, we would still say an apportionment is required.
Yeah.
So the apportionment issue is addressed in the second decision, and there are essentially 3 parts to this decision. So the first part concerns the appropriate starting point in valuing what the Upper Tribunal called the GC rights, in other words, the relevant interest, the rights under the Golden Contract. And as to that, the Upper Tribunal concludes at paragraph 22 that the appropriate starting point was to use the lowest of the values which had been arrived at by Mr. Watson, who was the LLP's valuation expert.
That is constructed but vacant.
Exactly, vacant possession. The second part of the decision concerned the amount of the adjustment to that value so as to take account of the benefit of the EZAs. And as to that, the Upper Tribunal concludes in its paragraphs 42 and 50, it concludes firstly that the amount of the uplift should be calculated on the basis that the total value of the EZAs should be discounted by a factor of 10% to take account of the risk of the allowances being denied. And secondly, it says that value should be divided, the benefit of the EZA should be divided between the developer and the LLP on a 50-50 basis, so assuming that they have equal bargaining power.
Yeah.
And then the third part of the decision concerns the approach to identifying how much of the price was paid for the relevant interest. Essentially, the apportionment question. And as to that, the Upper Tribunal concludes in paragraphs 57, 58 and 62 that the amount paid for the relevant interest should be taken to be the aggregate of the values of the relevant interest and the yearly sum uplifted by a factor of 29% to reflect the benefit of the EZAs as discounted and split between the parties on a 50-50 basis. And then at paragraph 73, the Upper Tribunal goes on to conclude that there was no need to assess or even consider the value of the other items for which the price was said to have been paid, in particular the Crsas. That wasn't something required by the exercise under section 296.
Yeah.
And we appeal against all of those conclusions. So part one, if you like, of ground three, the starting point for valuing the GC rights, we say that the Upper Tribunal's conclusion as to the appropriate starting point is predicated on a fundamental misunderstanding as to the nature of the exercise. So in its first decision, the Upper Tribunal sets out the various values in paragraph 264 of its decision.
Yeah.
And each of those values is essentially predicated on a different assumption. So the first basis of valuation assumes that the data centres are completed and income producing. The second basis of value assumes that the data centres are completed and let, but pre-incentives. And what Mr. Watson assumed by way of incentive was a 30-month rent-free period. And then his third basis of value assumes completed data centres, but with vacant possession. Now, in the second decision, the Upper Tribunal concludes that it's the third basis of value that ought to be adopted, because that was the value which most accurately reflected the value of the GC rights as they existed at the time of the investment. Now, in our submission, that conclusion was wrong in law. All of Mr. Watson's values reflected the value of the GC rights at the time of the investment. The difference between them was as to the assumption on which each value was assessed. So they're all market value valuations. They just proceed on a different assumption. And so the difference between each of those bases depends on what it is that you're trying to ascertain. Do you want to know the value of the property with vacant possession, or do you want to know the value of the property when it's fully income producing? And
well, what you want to know is what were the GC rights worth?
Yeah, but it depends on your on your assumption as to what you've got, if you like.
Well, what you've got is the right to have a building built in the future, and you take your chance on whether somebody might rent it, and if so, at what rent.
Well, that was essentially the Upper Tribunal's view, is that the value
Why is that legally incorrect?
The value that you're looking to is the value of the interest as it existed at the time.
Yes.
And the reason why we say that is wrong is that the aim of the exercise here is to find out what the LLP, what the purchaser paid for the relevant interest. That's the statutory question. So if you're asking, what did this particular purchaser pay for the relevant interest, we say that that is not necessarily, and in this instance is not, answered by simply asking what was the value of the investment in the state in which it stood at the time of investment. So putting it another way, the question of what these LLPs paid for the relevant interest is a more or has a subjective element to it. It is more involved than simply looking at.
Well, that might be so if they'd given any evidence about how they approached it, but the Upper Tribunal found they never negotiated it, they never gave any thought to it. all they did was they bought a package at a price set by the developer. And they assumed that there would be a target rent of X and a yield of Y, and that's what they paid.
Well,
So if the Upper Tribunal were right on your ground too, then they've got to ask themselves the question: well, what in reality did the LLPs pay for the rights under the Golden Contract?
yeah.
There's no evidence from the LLPs about their subjective thinking, so you fall back on a value, don't you?
Well, there is evidence as to how the LLPs approached the transaction, and it's all consistent with the LLPs regarding themselves as having bought an income-producing asset. So the evidence that we've got and the factual findings that we've got, returning then to
But they didn't. They didn't buy an income-producing asset.
No, but
They
that is how
bought
they...
an asset with the potential to be income-producing once a building had been constructed and a tenant found.
Yes, I understand that, but I'm saying that how they approached the evaluation of the investment opportunity was as an income-producing asset. That was the value to which they had regard when they assessed the overall commerciality of the proposal, of the opportunity. So we've already looked at 273 and 274 of the first decision.
I can't see how that works. If what you're trying to do is differentiate, assuming that you're wrong on the second point, if what you're trying to do is ascertain what they paid for the rights under the Golden Contract, as opposed to what they paid for the bolt-ons, the EZAs and so forth, because you only ever get to the EZAs and the RSAs on the basis that it isn't an income-producing asset at this stage, and therefore you need that extra income stream to protect you.
Yeah, but that's your point. Sort of, highlights the very artificiality of this exercise, because
sure, but assuming that it's right to have an artificial exercise, isn't it logically correct?
well, if you're asking what did these particular LLPs pay for these rights, then it's we say relevant to look at how they approach the transaction. So I mean, if I'm prepared to buy a vase off you for £1 million because I think it's a Ming vase and it's not a Ming vase, what did I pay for the vase? It's not very illuminating to ask what is the value of this piece of crockery that is not a Ming vase. What I paid, the more illuminating question is how did I approach the transaction? And if I regarded it as a Ming vase, then that is a strong indicator that I did pay £1 million for it, because that was my understanding, mistaken though it was. And in this instance, what the evidence shows is that the LLPs regarded this as an income-producing asset. That's what they wanted to know about, is what is its value on an income-producing basis. And there are three bits of evidence, if you like, or factual findings that I want to show you, which I say bear that out. So at 273 and 274, you can see there that the LLPs tested the reasonableness of the price by deducting the value of the EZAs and then sense checking the balance against the value of the data centres, assuming a rental of £170 per square foot and an 8% yield. So that's how they measured the value of the interest. Then at 278 is a reference to the DTZ valuations that were obtained by the LLPs. And those valuations... Sorry, 278.
Yep.
You can see there that at the time of agreeing the price, they can only have had in mind DTZ's estimate to the effect that if DC2 was fully fitted and let, at £170 per square foot, it would have a value of X, i.e. Mr. Watson's basis of valuation number 1. So what the LLPs asked DTZ to do was value the data centres on the assumption that they were fully fitted and let. That was the value that they were interested in. And then at 145...
Yes, but as the tribunal said in the last sentence of 278, those valuations didn't value what they were actually obtaining, but valued what they hoped to obtain in the future.
But that's the point. That was the value to which the LLPs looked, and that is informative as to what they were prepared to pay for it. And then again, paragraph 145
Of this same decision.
Of this same decision, yeah. You can see there that was the value at which the LLPs wrote down these investments in their accounts. So for those reasons, we say that the value to which the LLPs looked, they might have been wrong about that, but the value to which they looked was Watson basis number 1.
Basically, you're saying they overpaid for the rights they acquired.
That may well have been the
But that's a necessary concomitant of your argument, isn't it?
Well, it depends, again, on your view, doesn't it? I mean, there are lots of reasons why a purchaser might pay more for something than it is objectively worth. It doesn't mean that they've overpaid. They've paid the value that it has to them. So we say that the value to which if the question that you're asking is, what did these LLPs pay? Then the value to which the LLPs themselves looked is a better indicator of the price paid than simply looking at the objective market value of what in fact they acquired at the time, in the state that it existed at the time. So in 23 to 26 of the Upper Tribunal's decision, it gives 3 reasons for rejecting Watson basis 1. So first it is said that Mr. Watson's first basis of valuation necessarily involves taking into account the benefit of the RSAs and the ESAs. But as regards the RSAs, the Upper Tribunal has already accepted in its first decision that these are analogous to a warranty of value and as such ancillary to the relevant interest. So in our submission, it's perfectly rational to take them into account when assessing the value of the GC rights. And for the reasons already articulated, we say the same about the ESAs.
Sorry, I'm not understanding this. Paragraph 21, they say that Mr. Watson thought that his first and second basis didn't reflect what the LLPs were acquiring.
Yeah.
They were acquiring the right to have the data centres built
Yeah.
with associated rental supports. And he assesses on the basis of vacant possession plus the value of rental support, doesn't he? Isn't that what he's doing in his third valuation?
No, that was we'd have to go back to his report, but
Right.
What he does is he produces those 1, 2, 3, and then he reaches a separate conclusion that if what you want to identify is what they actually acquired in the state in which it was at the point of the investment, it is Watson number 3 plus his value of the yearly sum. So he produces...
That's somewhere in the first decision, isn't it?
Yes, I'm sure it is actually. we've got his report. It's certainly in there. Possibly. 265, yeah.
265.
265, yeah.
Thank you.
Yeah, so the point that the tribunal's making in 21 is that Mr. Watson's opinion as to the value of what was actually acquired as it existed at the point of investment was his third basis plus the value of the yearly sum.
What it boils down to, I think, this submission, is that the value, the objective market value of what was actually acquired is a different inquiry from what was the amount of money that the LLPs were prepared to and did pay for that item.
Yes. Yes, and that's of course what the tribunal acknowledges in 266 is that there's essentially no necessary correlation between those two.
Yeah. Yes.
So we say it makes no sense to isolate the relevant interest from its ancillary elements because that's not reflective of what the LLPs were acquiring. And in fact, those are the elements which justified the LLP's assumption that what they were acquiring justifies them looking to that value as an income-producing asset. So for those reasons, we say that the first reason for rejecting Watson 1 doesn't withstand scrutiny. The second reason which the tribunal gives for rejecting Watson 1 is in paragraph 25. And essentially it says that if the rationale for Watson 1 is said to be that the investors would look to the income to be derived, well, that doesn't of itself explain why you pick his first basis of valuation, because all of his bases of valuation were arrived at by reference to the income that could be derived. And we say, well, that may be true, but then it's also not a reason for preferring his third basis of valuation. But in any event, it misses the point of Mr. Smith's evidence. Mr. Smith's point was that in light of the wider arrangements, that is why investors would look to assess the value of the investment by reference to it on an income-producing basis. And as I've already submitted, that is indeed how these LLPs looked at the investments. And then the third of the Upper Tribunal's reasons for rejecting Watson 1 is said to be that it is wrong to adopt as a starting point for the valuation of the GC rights a value that includes the benefit of the yearly sum, because that would already take into account, at least in part, the benefit of the EZAs. And we have 2 points in response to that. The first is that, as you can see from paragraph 264 of the first decision, all of Mr. Watson's valuations excluded the value of the EZAs. And the second point is that in any event, if the yearly sum is properly to be regarded as an ancillary element, then it is entirely right, we say, to take it into account when valuing the relevant interest, because that is what was acquired. The EZAs are then a product of the price paid for that relevant interest, rather than the other way around. So we say none of the reasons put forward by the tribunal for rejecting Watson 1 are convincing. So the second part of this decision concerns the
Well,
question...
it's not really enough, is it, for you to say the reasons aren't convincing? You've got to say they disclose an error of law.
Well, yes, I mean, well, I essentially I say that their approach to the value was wrong.
Yeah. Now, your point, as my lady point said, is that what they were asked, the task they had set themselves was to ask what these LLPs had paid for the golden contract rights, whatever they were, not what was the market value of those rights.
Yes.
Yeah. Yes.
So the second part of this decision concerns the question of the value of the benefit of the EZAs. And as I said, there are two aspects to this. The Upper Tribunal starts by assessing the total value of the EZAs available to be shared, and then applies a discount to take account of the risk that the allowances would be denied. And in our submission, there is no evidential basis for such a discount. So in the first instance, and as the Upper Tribunal acknowledges in paragraph 41 sub 3, Mr. Mackey's valuation had proceeded on the basis of a discount of 20%. And as the Upper Tribunal acknowledges here, Mr. Mackey had no expertise to suggest that a purchaser would discount the value of the EZAs by a factor of 20% to reflect the risk of the EZAs not being available. And nor, in his experience, did investors typically discount the EZAs to reflect a perceived risk to that effect. So Mr. Mackey had no expertise or experience to suggest the discount. In the second place, there was no evidence to suggest that these investors had applied such a discount. And come back to the point made earlier, which is if the aim of the exercise is to identify what these LLPs paid for the relevant interest, adjusted so as to reflect the benefit of the EZAs, then we say it is highly informative that no such discount was considered by them to be appropriate. So in our submission, in the absence of any evidence that investors in general, still less any evidence that these investors apply a discount to reflect the risk that the allowances will be denied, there is simply no basis for the 10% discount which the Upper Tribunal applied in this case.
Yeah.
And indeed, the Upper Tribunal's approach to that discount is at odds with its conclusion regarding the proposition that the value of the EZAs should be adjusted so as to reflect only the incremental benefit of those allowances over and above any other allowances foregone on another hypothetical investment that might have been entered into. So at 41 sub 6, the Upper Tribunal here rejects the proposition again, Mr. Mackey's proposition that in assessing the value of the benefit of the EZAs, investors would take account of other tax benefits foregone, which they might have enjoyed had they entered into a different investment. And the Upper Tribunal rejects that proposition on the basis that there was no evidence to suggest that that was how investors approached the matter. And in our submission, they were obviously correct to reject that proposition. But by dint of that same reasoning, they ought properly to have concluded that there was no basis on which to apply a discount to take account of the fact of, or to take account of the perceived risk of the allowances being denied.
Well, isn't the finding about the discount also potentially at odds with the finding that the tribunal makes, which is that the purchasers simply take the pre-packaged figure that was given to them by the developer? Because if they're doing that and they're simply, here's the price, well, there's no wriggle room for a discount.
No. Yeah, there was no evidence that the discount was applied. Yeah, precisely. Or if they were going to, you'd expect at that point the investor to come back and say, well, hang on a minute, you know, we might
That's
not
a
get
bit pricey because we want to factor
we
in the risk.
might not get them, yeah. So then, as for the proportion in which the EZAs should be shared between the parties, the revenues expert, Mr. Mackey, contended that the parties should be assumed to have equal bargaining power, and as a result they would look to share the benefit 50-50. The LLP's expert, Mr. Smith, contended that the parties would look to split the benefit 80-20 in the developer's favour. Now, at 43-50 of the decision, the Upper Tribunal sets out its reasons for rejecting the evidence of Mr. Smith and instead preferring Mr. Mackey's evidence. And in our submission, the reasons that the tribunal gives for rejecting Mr. Smith's evidence are irrational and wrong. So first, it is said in paragraph 44 that Mr. Smith's evidence suffered from the limitation that it was based on his experience of other transactions that almost without exception resembled the very transaction in issue. In other words, transactions that include a package of finance and rental support arrangements. Now, in our submission, the fact that Mr. Smith's evidence was almost exclusively concerned with transactions of this very kind is not a valid reason for rejecting his evidence. It is, in fact, a reason for preferring his evidence over that of Mr. Mackey, whose experience was more limited.
How does a tribunal preferring one witness to another make an error of law?
Well, because the basis on which the tribunal reject his evidence is an irrational reason. Right. To reject an expert's evidence because it's too close to the transaction with which you are concerned, we say, is not a valid reason for rejecting.
That's not what the Upper Tribunal were doing. They weren't saying at this stage, having decided they needed to disaggregate the overall price, they were looking for expertise in how to make that disaggregation. So if Mr. Smith turns up and says, well, I've advised in lots of these transactions, but we've never disaggregated the price, I don't see that it's irrational for the Upper Tribunal to say, well, that's not much help when the exercise we are embarking upon requires us to disaggregate the price.
Well, and they, as I've already submitted, they misunderstood the aim of the exercise. The aim of the exercise here is to identify what these LLPs paid for the relevant interest.
Yeah.
And the fact that Mr. Smith has evidence about how these types of transactions, these very transactions are approached, we say to reject his evidence on that basis is irrational in the context of the exercise which the Upper Tribunal should have been carrying out.
But you gain support, don't you, from the fact that they say that it provides but relatively weak evidence as to the market value of the building.
Yes.
Which of course is not. It's the price that they're looking at, and the
Yes.
price that's the part of the price that is attributable to the EZAs, and the part of the price which is attributable to the rights under the development contract.
Yes.
Yeah.
So, in terms of Mr. Mackey's experience, the Upper Tribunal acknowledges in paragraph 38 that the typical market participant in an EZ investment is an LLP or a syndicate of higher rate taxpayers rather than corporate investors. And at 41 sub 6, the Tribunal acknowledges that Mr. Mackey's experience is limited to advising corporate buyers. So for those reasons, we say that it was irrational to reject Mr. Smith's evidence and prefer Mr. Mackey's evidence, given the nature of the exercise at hand. It was also said that Mr. Smith's experience of investors paying a price 66.7% above what would have been the market value of the building outside an EZ provided weak evidence as to the market value of the building, since given the presence of rental support and so on, it was possible that the other investors with which Mr. Smith had been involved were also acquiring assets in addition to the relevant interest, which would have a significant market value. Now, that may be so, but it doesn't explain why Mr. Smith's assessment of the uplift, which was based on his evaluation of the bargaining power between the parties, would be any different. In other words, even if Mr. Smith's assessment of the value of the relevant interest is flawed, which for the reasons I've already articulated, we say it's not. But even if it is flawed, it doesn't follow that his assessment of the uplift was wrong.
Well, that's the next paragraph, isn't it?
46? Yeah, so that's the second reason. So the second reason why the Upper Tribunal rejected the evidence of Mr. Smith was because it said that an 80-20 split in favour of the developer only made sense if the developer was providing something other than the relevant interest. But again, on the Upper Tribunal's own analysis, and as it goes on to acknowledge, the developer was providing something else other than the GC rights. So, with respect, it's extremely difficult to follow the Upper Tribunal's reasoning here, but we say at face value, it would seem to be another reason for accepting the evidence of Mr. Smith.
Yeah.
But in any event, Mr. Smith's assessment of the parties' respective bargaining positions is in fact more nuanced than the Upper Tribunal implies there at 46. The point was not simply, as suggested in 46, that the investment represented the last chance saloon, if you like, the last opportunity to invest in EZ investments because the regime was coming to an end. And the Tribunal says that that's a point that cuts both ways. The point, as Mr. Smith explains, is that it was to do with the particular timing of these particular transactions. And it was a sort of triumvirate of factors. It was that we were at the end of the tax year, we were at the end of the final tax year for EZAs, and that was in a year in which the highest rate of tax was 50%. So, and it was the confluence of those factors that meant that the simple dynamics of supply and demand pushed the balance of the bargaining power in the developer's direction. So the fact that the investments took place at the end of the regime is not a point which simply means that the balance of bargaining power is even. Of course, it means that the developer needs to sell, but what the developer has is rare, and indeed it's soon to be extinct. That the rareness of its offering doesn't change because you're coming to the end of the regime. So the supply side of the equation stays the same. The demand,
if he doesn't sell it by the end of the tax year, it's of virtually no value to any investor at all.
Absolutely. But in terms
so there's an imperative to get it sold, isn't there?
It is, yes. But in terms of supply and demand, the demand side of the equation is only likely to increase as a result of being at the last chance saloon. And so that was the point of that of Mr. Smith's evidence, that it's just simple supply and demand. So
there wasn't any evidence, was there, that there were other consortia of investors and LLPs queuing up to take on this building if this particular deal fell through?
There certainly weren't other. There certainly weren't other consortia. But what there was, so the reason why there are two investments here is because the investment round for CDC2 was oversubscribed, and that's why a second investment opportunity was put together. Right. So it was reflecting that demand. So we say it was irrational of the Upper Tribunal to reject Mr. Smith's evidence. And then the third part of the decision concerns the proper approach to identifying how much of the price was paid for the relevant interest. And in our submission, having concluded that part of the price was paid for the relevant interest and part for the ESAs, part for the Crsas and part for the arranger's fee, what the Upper Tribunal should have done was carried out the apportionment exercise envisaged in 286 of its first decision. Instead, the Upper Tribunal gives three reasons at 66 to 69 as to why it no longer considered that an apportionment was necessary. So first, it says that whilst the Crsas constituted a separate part of the consideration for which the price was paid, they couldn't properly be regarded as separate and distinct assets in the same sense as the land and buildings in Bostock. And that was because the fundamental benefit of the Crsas was to enable the LLPs to pay a higher purchase price for the relevant interest. And we say that there are a number of difficulties with this part of the Upper Tribunal's reasoning. So in the first instance, it is entirely unclear how, for the purposes of section 296, these elements are to be regarded as separate assets for which part of the price was paid, but they're not separate enough as to necessitate an apportionment under the very same provision. In our submission, there are only three possible analyses. Either these elements are separate for the purposes of section 296, in which case an apportionment is required, or they are separate components of the relevant interest for the purposes of section 356, in which case an apportionment is required, or they are not really separate at all. They are ancillary to the relevant interest, in which case no apportionment is required. And we say whether they are separate for the purposes of 296 or 356 makes no difference. In each instance, what is required is that the separate elements are valued and an apportionment carried out. And the reason why each element must be valued and an apportionment carried out is because if only one element is valued and the remainder of the price is simply attributed to the other element, it is entirely possible and indeed probable that the amount simply attributed to the other element is too much or too little. And that is because, as the tribunal itself acknowledged, there is no necessary correlation between the price paid and the market value of the asset. So the flaw in the Upper Tribunal's approach is that it effectively assumes that the price paid was equal to the market value. And so on the tribunal's approach, having established the market value of the relevant interest, the Upper Tribunal says it follows, essentially, that the remainder of the price can properly be regarded as the value of and equal to the remaining price. And in our submission, that is not a safe assumption to make. And in this case, it produces a seriously distorted picture. So the reason why it's necessary to value each separate element and then apportion the price is illustrated by the Bostock case itself, which is in volume A behind tab 17. We can pick it up at 324.
Sorry, which page?
Page 324. And it's under the heading the apportionment.
Yeah.
And what you can see there is that the aggregate value of the two elements, the land and the construction costs, was...
Can we just tell us just what's going on here?
So this is a case.
So T purchased a development site, then use it for processing, then decides to develop, incurs and so he's already got the land, he builds a building, and then he lets it and sells the income producing investment. That's what's happening.
Yes, so you've got a price paid for the relevant interest. The relevant interest includes the land on which the building is built.
Right, and the statute tells you to strip out the land.
So you need an apportionment in that instance. And what you can see under the heading the apportionment is that the aggregate value of the two elements, the land and the cost, is £533,000. And that left a surplus price of almost £600,000. So the issue in Bostock was whether the surplus should simply be attributed to the building, which Sir John Vinelot describes as not involving an apportionment at all. And instead he concludes that the fair and just result is to ratably apportion that surplus between those two elements. Now, as far as the method of apportionment is concerned, we don't understand the Upper Tribunal to have taken issue with the correctness of the method adopted in Bostock. The issue in our case is whether an apportionment is required at all.
Yeah. What is the statutory provision that Sir John was applying?
Well, it's the forerunner to 356.
Yeah. Can we just look at that?
It's 356.
Is it page 313?
313, yeah.
Is it references to expenditure do not include expenditure incurred on the acquisition of rights of land? Is that what he's applying? What's he doing?
It is.
Oh, it's
just
section
below
21.3, is it?
Yeah, 21.3.
Yeah.
Reduced by an amount equal as on a just apportionment as attributable ...
Right. So what he's doing is he's carrying out that statutory instruction.
He is, yeah. And of course that's one of the observations that the Upper Tribunal makes, is that 356 has an express apportionment within it, whereas 296, the Upper Tribunal says in its first decision anyway that it's implicit within 296 because it's I think they call it the gateway or the threshold provision. But there's no issue about if an apportionment is required, then the approach in Bostock is how you approach an apportionment. The issue is whether an apportionment is required at all. But Bostock is illustrative of the point that if only one of those elements had been valued and assumed to correlate to the price, and the remainder of the price simply attributed to the other element, it would have produced a distortion. It wouldn't have produced a just and fair result. Now, in this case, the Upper Tribunal seeks to sidestep the need for a valuation of each of the elements and followed by an apportionment by suggesting at paragraph 64 that whether or not an apportionment is required under 296 all depends on the nature of the transaction and the relationship between the component elements. Now, in our submission, the nature of the transaction and the relationship between the component elements is what tells you whether the elements are really separate and distinct from one another or whether they are really ancillary. But once you've decided that the elements are separate and distinct, then in our submission it inevitably follows that an apportionment is required. But the idea that these elements are separate items for which part of the price was paid for the purposes of section 296, but they're not appositely separate for the purposes of determining what the price was paid for under the very same provision, is impossible to follow in our submission. Either the element is separate for the purposes of 296 or it is not. It cannot be both simultaneously.
No Schrodinger's cat.
No Schrodinger's cat. So we say that it follows that either the Upper Tribunal was wrong to regard these elements as separate, or it was wrong to conclude that there was no need for an apportionment, but it cannot be right on both counts. The second reason which the Upper Tribunal gives as to why an apportionment is unnecessary is essentially that because there'd been no negotiation of the price in this case, the tribunal regarded there as being no reason to doubt the correlation between market value and price paid. And instead, what's said in paragraph 68 is that the LLPs simply made assumptions as to the market value of the data centres and relied on the other rights and benefits to ensure that value flowed back to them from the developer to the extent that the price turned out to be an overpayment. I would say three things in response to that. First, whilst it is true there was no negotiation of the price here, it is not correct to say that the LLPs simply made assumptions as to the market value of the data centres. The LLP's view as to the value of the data centres was informed by the DTZ valuations they obtained. And indeed, the reasonableness of the price was assessed by them by reference to those values. They didn't simply assume the value of the data centres. Secondly, it doesn't follow from the fact that there was no negotiation of the price that the price paid must necessarily correlate with the market value as assessed by the Upper Tribunal. As I said, there are lots of reasons why the price paid by a purchaser doesn't necessarily correlate to the market value. As the tribunal acknowledges, there might be a bad bargain, there might be a mistake as to the nature of the asset, or the purchaser may place a particular value on it. And as I say, in the present case, the evidence indicates that the LLPs did place a particular value on these investments. They considered themselves to be paying the whole of the price for the relevant interest, together with the rights and benefits, and including the benefit of the EZAs. That was their understanding. So in those circumstances, the market value of the relevant interest as assessed by the Upper Tribunal, i.e. just looking at it from the perspective of what it was that they actually acquired as it existed at the point of investment, we say is highly unlikely to correlate to the price paid for it. But in any event, even if the price wasn't negotiated, it doesn't follow from that the proper way to approach this exercise is to value one element and then attribute the remainder of the price to the others. That approach has no logical basis. If you're going to approach the exercise by looking at value, then you should do that consistently. And then the third reason which the tribunal gives as to why an apportionment is said to be unnecessary is that the calculation of the market value of the GC rights already factors in an element of profit for the developer, and therefore the clear inference in the Upper Tribunal's view is that the whole of the excess price must be attributable to the other elements. But to say that the value of the GC rights already factors in an element of profit for the developer rather assumes that the Upper Tribunal's valuation is correct. But in any event, again, that is not a reason for simply evaluating the objective market value of the relevant interest and then equating that with the price paid for it and then attributing the remainder to the other elements.
Yeah.
So it follows from all of that that we say that the Upper Tribunal was wrong in declining to take into account the expert evidence before it as to the value of the Crsas. And we say whether the exercise under 296 calls for an apportionment or merely a direct assessment of the price paid for the relevant interest, it is plainly relevant and instructive to consider the value of the other elements for which it is said the price was paid. And in our submission, that is what the Upper Tribunal should have done. But instead, by adopting the course that it did, and simply attributing the remainder of the price to the Crsas and the arranger's fee, the Upper Tribunal's approach produces a result which we say is simply not credible. So the remainder of the price, which the Upper Tribunal effectively attributes to the Crsas, is £67.7 million in the case of DC2. You get that number by deducting from the price paid the value, the uplifted value of the relevant interest and the yearly sum to take account of the EZAs, and also deducting the amount of the arranger's fee, which the Upper Tribunal says it doesn't need to evaluate it because it's in a fixed amount. And what you end up with is £67.7 million out of the total price paid. Now, if no value is properly attributable to the cash collateral element of the Crsas, then essentially 67.7 million is what the LLPs are assumed to have paid for the right to the developer loan and the right of conversion. And that implied value is almost 13 million more than the developer loan which the LLPs had assumed for the purposes of their own financial model. So if we turn up paragraph 146 sub 2 of the first decision, the Upper Tribunal sets out the contents of the financial forecast, the spreadsheets which have been produced by Mr. Fielding. And you'll see there the assumption in sub 2 of a balance needed to repay the bank winter loan, £54.9 million in brackets. So that's the amount that the LLPs in their projections had assumed. And that is £13 million less than they are assumed to have paid for that right. It's also almost 98% of the full amount of the developer loan which Mr. Mackey assumed for the purposes of his valuation. And you'll find Mr. Mackey's assumed value of the developer loan in volume A, tab 10, para 5.2.16. So we say that the upshot of the Upper Tribunal's approach is to regard the LLP as having paid £67.7 million for the possibility of receiving a full recourse loan of either 54.9 million on the LLP's assumption or 69.4 million on Mr. Mackey's assumption. And in our submission, that is simply not a credible assumption, or incredible result. In our submission, that is a powerful indicator that the Upper Tribunal's approach is wrong. So for all those reasons, we say that the Upper Tribunal erred in its approach to the apportionment issue. If it was going to go down that line, what it should have done was value each of the identified elements and apportion the price between them. So that then leaves open the question of what you should do if disagree with me in relation to grounds 1 and 2, but agree with me in relation to ground 3. Now, you have before you the Upper Tribunal's findings of fact. You've got the expert reports and you've got the transcripts of the expert evidence. So it is in principle open to you to decide the issue for yourselves. And we set out in paragraphs 40 to 45 of our skeleton how we say the apportionment issue should be resolved. But you may have little appetite for that particular option. And so the more pragmatic solution may be to remit the matter back to the Upper Tribunal, who of course had the benefit of hearing the evidence the first time around, with guidance as to how they should go about resolving the issue. And we would respectfully submit that that guidance should include the following. Firstly, what the apportionment exercise requires. And as to that, we set that out in paragraph 41 of our skeleton argument, but in essence, valuing each of the elements and apportioning the price between those elements in a way that is fair and just. Secondly, guidance as to the correct starting point for the valuation of the relevant interest. In other words, is it the value of the asset as it existed at the time of the investment, or is it more pertinent to look to the value which the LLPs had regard when assessing the opportunity? And then thirdly, guidance as to the approach to the question of the effect of the EZAs. In other words, should they be discounted to reflect hypotheticals? And how should the benefit of the allowances be split between parties?
Yeah. Just remind me, where do you deal with the question of what we should do if we are with you on this ground?
So it's in our skeleton argument,
Yeah.
40 to 45. We set out essentially
40 to 45 is looking at Watson's evidence. Are you talking about page 40 to 45?
Sorry. Yeah, so page 67.
67. Yeah.
Under the heading proper resolution of the apportionment issue.
Mm-hmm.
So 40, well, in overview, 41 is the steps that we say.
Well, I follow, but no, I'm just thinking about the order that we would make, whether we decide it or it goes back to the Upper Tribunal. I mean, I'm not that familiar, I have to say, with appeals from the Upper Tribunal exercising its original jurisdiction. If this were a second appeal, then I think the way that you would get to the position that you say we're in is you would say that this court has all the powers of the lower court, i.e. the Upper Tribunal. Under the Tribunals, etc. Act, the Upper Tribunal, if it finds an error of law in the first tier, can remake the decision. Mm. Therefore, we can remake the decision. Therefore, we have that power. But we don't have, although we have the powers of the lower court, that's enough, you say, to allow us to make a factual decision if we come to the conclusion on your ground 3 that the Upper Tribunal erred in law. That's how it works.
I think we both.
Mr. Hewitt disagrees. Well, we may have to have some argument about that.
It doesn't work. It works like that, but not for the reason that you gave.
Right.
There's a section in TCEA for the Code of Appeal which is identical to the section that the
is there?
has. Yeah.
Right.
So you have all the same powers, but expressly under the TCEA.
All right. Thank you.
Yeah. So I mean, if you are minded to decide it for yourselves, we produced a note on the evidence below, and we can certainly hand that up to you.
think we've probably got enough to decide.
I would have thought so. So those are our submissions.
Right, thank you. Mr. Ewart, do you start at 2 o'clock?
Good idea.
Now, we seem to be doing quite well for time. The LLP's appeal was supposed to be 45 minutes into tomorrow. So we ought to finish at any rate by tomorrow midday, I would have thought.
I'm hopeful we'd finish today, but
Today would be very good. All right, 2 o'clock.
yeah.